the office for a long time, and it really has been a pleasure to provide these, hopefully public services to community members. In terms of, as she said, it's really a special occasion for me because this year marks 20 years that I have been focusing my legal practice on community associations. And so a big milestone, and very proud of that. So today we're going to be covering what used to be broadly, considered community associations, but recently has been given a new name, which is, as the title indicates, common interest community associations. That is because of a comprehensive new law that Wakiowa that we will discuss later in the presentation. But for today, we're going to be covering those, which is a broad umbrella for condominium associations, homeowners associations, plat communities, and others as well. And so this is a comprehensive law. It doesn't apply in full to everyone yet, as we'll cover in a moment, but it's something that is coming for you as far as your applicability and your compliance. So as we move to the first, what I wanted to start with is that this is what I'm going to cover today is meant to be a typical monthly board meeting. It's meant to be covering the major areas, perhaps, that would be covered in terms of the major responsibilities that a board has on a day-to-day basis. Obviously, there are many responsibilities, many duties that the board has to the owners and to the community. But I wanted to focus, since we're limited in time, on several that are going to come up regularly. Those respond, and you'll notice an R theme here. The key responsibilities that I wanted to discuss today, as we will in more detail momentarily, are resources, the finances, reserves, what you are saving, the records that you're required to keep, and then the rules enforcement, the rule making process, which is obviously very important in terms of the community. And another R, perhaps, is that recent changes to Washington laws, whether it's today or in the future, really, because Washington laws about common interest community associations seem to be changing almost every year. It can be difficult to keep track, especially with changing board composition, in new elections. And this often requires legal guidance to understand what your changing, shifting obligations are. That didn't used to be the case, I'll say, but it is now. It seems as if there really is little way to fully comply without periodically receiving legal guidance. First things first, I should say, is the disclaimer before we get to those responsibilities, is that this presentation is not legal advice either by myself or by the Secretary of State's office. If your association has a legal issue, then it should contact a licensed attorney. And before I move into the types of associations, I should say is that for the questions section of this presentation, I'm not permitted, because I don't represent any of the associations here today that might be represented or their owners. I am not able to provide any specific guidance or advice about your situation. This is meant to be a general presentation that gives you some sense of the law today. So one of the questions that is fundamental before we get into the responsibilities right now is what type of association you are, and in relation to that, what law applies to you. Obviously, as we'll get to, the governing documents provide a source of authority on that, but also, even over the governing documents, is the state laws that apply. And as you can see, there are Right now, anyway, currently, there are several different laws that might apply to community associations, common interest associations, community associations now. The first is condominium associations. As you see, right now, any condominium association that was created, their declaration was recorded, after, July of 2018, those are already subject to the new comprehensive law, the Wakaiwa that I mentioned, which is here 64 RCW 6490. But the older condominiums before 2018, they are covered by one of two other laws, plus certain portions of RCW 6490, the new law. So it's confusing right now. The good news is that in the near future, this new comprehensive law, RCW 6490, Wakaiwa, it will apply to everyone. And whether you were created in 2018 or not, or whether you were created in 1978, it will apply to everyone, condominium associations and all the other associations on this slide, this list. So that will simplify matters, and that happens at the beginning of 2028. So in several years from now, this will all be much more clear. But for the time being, it really depends on when your association was created. In the case, as I said, of the newest law, RCW 6490, it would be in July of 2018. But then, if you are a condominium association, once again, that was created before that, but after the July of 1990, then you're subject to RCW 6434, the preceding section here. And if you were a condominium association created before that, then you would be subject primarily to RCW, the previous one, 6432. Very confusing, even for attorneys that practice in the area. You have to constantly cross-reference. And what makes it worse is that certain provisions of the newer law apply to all associations, and certain provisions of the middle law, 6434, apply to the 6432 associations, the older associations. Very, very difficult to understand, once again, but that will be simplified soon. In addition to condominium associations, you have homeowners associations, which are typically single family. That is a different law that applies, at least right now, for the most part, is RCW 6438, and much shorter law than the preceding ones. But also RCW 6490 does apply, as we'll discuss, to certain portions of homeowners associations as well. Then you have cooperatives, which are not as common. That's a separate law, RCW 2386, and then also 6490 to a small extent. And then you have everyone else, as I said, that is the more recent associations over the last 7 years, which is just the common interest community associations with the new law. So you have to really know what type, obviously, association we are, but then based on when we're created, what laws apply to us. And as I said before, generally it's at least 2, if not 3. Before moving to the responsibilities, once again, a general matter that you'll hear attorneys refer to is your governing documents, your association's governing documents. In the case of a homeowners association, that would be your CC&Rs, your covenants, conditions, and restrictions. In the case of, and also any bylaws and rules that the association, the board adopts. In the case of a condominium association, it would be your condominium declaration, in addition to the bylaws and rules. So you have these governing documents that, in addition to the state laws that were just discussed and that will be discussed, you have these governing documents, the constitution, if you will, of your association. It lays out the powers that the association can exercise, any restrictions on what the association or the owners can do, their behavior, Obviously, any controls on architecture, any assessment related provisions, and then procedural matters and enforcement matters as well. And if you want to amend any of those governing documents, then they will typically at the end provide a procedure to do so. Rules, the lowest category, can typically, as we'll discuss, be adopted or amended by the board. But bylaws, the procedural document, and then the CCRs or declaration, those typically involve a supermajority of either 60%, 67%, 75, 90. There are varying approval that is required. And that also sometimes requires legal guidance to determine what level of owner approval or any is required. It's also fundamental, foundational before discussing these responsibilities is that you have to have meetings. You have to keep the owners involved in the affairs of the association if you're on the board. Annual meetings at the minimum are required, and then special meetings may be called in various ways, and including by owners with 10% of the vote are permitted to call a special meeting. But you need to make sure that the meetings are open, including, in the case of homeowners associations, their meetings have to be largely open to the owners to observe. That's not the case for condo associations, again, confusingly, at least right now. But in the case of homeowners associations, they need to be open. And in case of both board meetings and the larger owners meetings, you need to keep minutes that are sufficient to demonstrate the decisions that were made in terms of finances, in terms of enforcement, those sorts of matters. The board may enter into executive session in certain listed situations in the statute, but even if it does, that is simply shielding its discussions. If it takes any actions, it has to be ratified in open session. And so there's a limited ability to convene and discuss matters candidly, if you will. Quorums are, in terms of meetings, just simply the number of people that need to be there to make it a valid meeting. There are some default quorums, once again, that are stated both in the governing documents and in state laws. In terms of the state laws, HOAs, homeowners associations, are 34% of the total ownership. And in the condo, the default is 25 of the total ownership. Your declaration may vary in that, obviously, but those are the minimums that are the defaults. Now coming to the main topic is obviously the board of directors and how it governs the association, manages it. These are elected, the directors are elected by the owners in accordance with whatever the procedures that are contained in its governing documents, obviously. The board is trusted, and it's a responsibility that is given to them by the owners to act on the behalf of the association, which means behalf of the community, behalf of the other owners. So you have responsibilities if you're a director to the common good, to the whole, to the corporation, not just individuals or groups within it. There are duties, therefore, of care in the performance of your responsibilities, whether it's being informed or investigating, seeking advice, all of that. You need to be making sure as part of this that you are making an effort, and that's what a duty of care means. And loyalty means your loyalty, again, to the corporation, to the association, to the common good. The board does have obviously the primary responsibility to enforce the covenants, to enforce the rules. If it fails to do so and harm results from that, it opens itself, the association at the very least, and its insurance up to liability. In some limited cases, also the directors, but not as common. And as I said in the previous slide, minutes must be kept regarding all decisions that are made, whether by the association or by the board. As we'll discuss momentarily, once again, there are record-keeping requirements imposed by recent laws that are extensive, including meeting minutes. The board has many powers. The association in general has many powers, and then the board is empowered typically to act on behalf of the association in exercising them. This means that unless it's otherwise provided, which can be the case in your governing documents, the association, acting through the board, has the ability to adopt rules as long as they are consistent with the primary documents, the CCRs, the covenants, or the condominium declaration. Those are primary, and so the rules that are adopted by the board cannot conflict with them, but they can supplement them, they can expand upon them, they can clarify them. To some extent, they can add to them as long as they're not conflicting, once again, inconsistent. The board can also make other actions, such as entering into contracts, adopting budgets, as we'll discuss more, imposing late fees for delinquent assessments, and reasonable, as we'll discuss again, fines for violations. It also has the primary responsibility to regulate the common areas, their use and their maintenance and repair. And that is a responsibility that takes a lot of investigation and consultation with other professionals, such as reserve professionals. Moving to the first R, as we said, is resources. That begins with budgets. You are required as a board to provide sufficient resources to at the minimum to maintain, repair, and replace the common elements as they need to be done. So that involves annual and special budgets that provide for assessments on the owners that are initially adopted by the board. Once again, the board adopts the budget, but based on a state law that applies to everyone, all community associations, not just the newer ones, those budgets that are adopted by the board then need to be ratified by the owners. And ratification, what that means is that after the owners have been provided with the budget, as it's stated here, at least 2 weeks up to 2 months before a meeting, the budget's approved unless it's rejected. So it's an opt-out standard by a majority of the total number of owners at that meeting. And so really, it's a standard that unless at least 51% of the total number of owners in the association vote no, it's ratified. And so board adopted budgets are almost always ratified because it doesn't even require this legal standard for there to be a quorum. So if no one showed up to the meeting, it's ratified. So it typically that is what occurs, but you have to go through the procedural steps or else it's vulnerable to challenge. The second R is reserve studies. Reserve studies are required unless you fall within an exception. And there are several exceptions, and once again, they vary based on when your association was created. But there are limited exceptions to them. Some of them are discussed here in this slide. Suppose the association has only nominal reserve costs, as that's defined here, or if the cost of the reserve study or update exceeds 10% of the annual budget, which it's rarely the case with regards to condominium associations, unless they're very small, but it could be the case with regard to some plat communities and homeowners associations. So these are limited exceptions. Then they were not required. Nominal reserve costs here has a specific meaning that is listed there based on percentages of budget expenses. So there are ways to be not subject to the reserve study requirement, but it's safe to assume for larger homeowners associations and all condominium associations that it's a requirement that you must comply. Reserve studies are obtained by consulting with a certified reserve professional, and they come out to the site and they perform an inspection. They determine what are the association's common element and limited common element responsibilities to repair and replace, and then they draft a study, a document that shows you, how you need to save over time in order to repair and replace, those common elements over their useful expected life. So, in other words, if you have a 30-year roof, then it tells you how much you need to save in order to have the money to replace it in 30 years, and counting for inflation and so forth. So it's meant to be a savings plan, more or less. However, as we'll discuss, it's informational. You get it as a result of an inspection, a site visit, and then it's supposed to be inspected every year, but it's only required to be based on a site inspection, the more expensive aspect, every three. So you're able for every 3 years to incur this expense, but the annual is something that can be much more limited, where you just simply update it to account for any expenses that you have had to incur or in advance or unexpectedly. However, this is meant to be a reserve study. It's meant to, among other things, tell the owners and prospective owners about the long-term financial health of the association. It's meant to give them that information. There have been cases in the past where an owner will buy a property that is subject to, that is their association has not, set aside reserves. There'll be a major special assessment, and that's something that's an unpleasant surprise. This is meant to give those prospective purchasers a notice of that, potential situation, the risk of that. And so if the association does not have an updated reserve study, then it has to disclose that on a resale certificate when there is a potential sale of the unit. And I can tell you that it is often a red flag. At the very minimum, it will spur additional investigation of the situation, and it can, in cases, cause sales to fall through. Those were the reserve study, and there are certainly a number of other laws and regulations that apply to reserve studies, but those are the main ones. The reserve accounts are a different matter. The reserve studies are required unless you fall within an exception. But reserve accounts, the state law encourages community associations to have these reserve accounts, to open them, to maintain them, but it doesn't require them to actually fund the reserve studies, to actually deposit money into these reserve accounts. So it's a very limited, in terms of the actual accounts, the actual funds, a very limited standard. If you do have reserve funds, you have the ability to, as an association, to withdraw them to meet unexpected expenses. But you have to note that in the minutes, you have to notify the owners, and you have to adopt a repayment schedule. So once again, there are limits on that ability to to withdraw money early to account for other unexpected expenses, which does occur. The record keeping is the next R is perhaps the most problematic, because it requires you to review and evaluate lengthy state laws regarding what you are required to keep. These standards, were recently, over the last several years, have been updated and expanded upon by several laws. One of them is a law applying to corporations, nonprofit corporations, RCW 2403. But another law is this, again, the 6490, the Wakiowa, that has a long list of records that are required to be kept by community associations. So you, at the very minimum, you need to know what that site of that law is and be able to understand what your requirements are, because the legislature has spelled out in some detail, what sorts of documents and information these types of associations are required to keep. So at this point, it's just a matter of following that statute, but it's more than it used to be. That statute also, contains new requirements relating to notice in terms of providing owners with requested records. So owners are generally entitled to review the association's records, but this goes into more specificity about provision of them. But in general terms, as I've said, meeting minutes, financial records, budgets, notices to owners, things of that nature are going to have to be kept for 7 years is generally the standard. Some of them less, but it is something that is a long-term commitment to keep, store, and upon request provide these records. A good rule of thumb is that any major action, whether it's rules enforcement or any kind of litigation or any kind of special assessment, you should keep everything about that, because those types of matters, of course, are the most likely to be challenged. The rules aspect of this is starting with the most major rules, or what you can build, architectural controls. And the association, acting through the board, needs to act promptly, though, typically within 30 days of an application, to build a new structure. Then then the association, the board, or the architectural control committee is obligated to respond at the very least. And if it does not, some governing documents will say that it's automatically approved. So there is an obligation to respond promptly, and that's what it would mean within a month in many cases. But also, of course, there has to be an enforcement in the same manner for all similarly situated owners. And that's the key term that is difficult in terms of, as we'll say in a minute, making exceptions. You have to make principled exceptions. And so everyone in which generally is in the same position, they should be treated the same. And so there should be a good reason to make an exception, as we'll see. And you need to maintain any records that demonstrate that procedures have either been followed in terms of architectural controls and other rules, frankly, and that reasonable decisions have been made. It is, again, a helpful exercise as a board to say that we can anticipate that this is a major enough decision, that a rejection, say, of an application, that we can anticipate that it might be challenged in court. It might be litigated. If so, you want all the information and documents that you can have. In terms of rules violations, either the association or the owners have a right to sue for damages. Now, suing for damages is a very lengthy and expensive process, or seeking an injunction. And so I view it as more theoretical unless it is a major, major violation, because in many cases, the association and certainly an affected owner, is just not going to be willing to spend the time and resources to litigate this, and whatever the issue is, unless again it's significant, and because the association or the owner is not guaranteed to get to recover their attorney's fees that they would spend in that endeavor. The court has the ability, but not the obligation, to award the prevailing party, if it is the prevailing party, with their reasonable attorney's fees. But that doesn't mean that they would get paid everything. And so there's a lot of risk involved in litigation. And so therefore, the primary way to enforce the rules and to address violations is through fines. But fines have to be based on a previously approved schedule. that's been distributed, to the owners after, and that's been distributed to the owners, the schedule. So there's certain procedures that need to be followed with regard to giving everyone the notice that if they violate the documents, these are the financial penalties that they are subject to. That's really all that this means. But then, if an owner then, after that schedule has been approved and provided, if an owner violates the covenants at that time, the rules, then the association still, before it imposes a fine, needs to notify that owner in question that it is accused of violating a rule and that the board is considering a fine. And then it needs to give the owner in question the opportunity to be heard, the opportunity to contest it or to explain why that a fine should not be otherwise imposed. So there's a process. This is just a simple due process procedure that a fine just can't be imposed without, a hearing. As as I alluded to before, there is a requirement that the board enforce the rules consistently. And in many cases, boards will be either of the impression that they have to be strictly across the board enforcing the rules, or that that's just their preference to do so. It's not a requirement, however. The board has the choice to make exceptions, but they have to be principled exceptions. There have to be, again, similarly situated owners need to be treated consistently, or else, once again, there is the potential for litigation that the association would lose. So, if you do make exceptions, you need to there needs to be an effort, to explain in the minutes why the exception is being made, the basis for it, and that protects you. If you don't do this, if you do not enforce the rules, then it's possible that you, the association, and the board will lose the ability to do so if there is litigation. If this is a rule that has been violated for a substantial period of time in an open manner, then through various legal principles like abandonment and waiver, there could be the association could lose its ability, at least in that case, and perhaps all cases, to enforce the rule. And so that is part of the board's responsibility to engage in rules enforcement, which is obviously an unpleasant situation for any board. However, it should be emphasized is that the occasional violation of minor infractions is not going to show a more general abandonment or waiver of the ability to enforce the covenants. It has to be something significant. Now, in terms of when there is a dispute regarding the rules enforcement or any other type of litigation between an owner and the association, then there are, again, certain due process procedures in terms of the rule enforcement that have to be followed. Typically, they fall into the mediation and then possibly arbitration categories. Mediation is a certainty if the legal process is begun. It's required for any litigant to engage in non-binding mediation, where a professional is appointed to attempt to work out a mutually acceptable settlement. However, they don't have the ability to force the parties, to settle it. Arbitration, on the other hand, it's required in some cases in many counties, in these types of lawsuits for larger matters. And it's a more expensive process that is meant to arrive at a result, but not as expensive or as time consuming as litigation. So in that case, the arbitrator does have typically the ability to render a binding decision. The problem is that in many cases, the parties have to agree on the arbitrator or your panel, which can be difficult. But if they can get past that, and then they submit written statements and evidence, present oral arguments, it's essentially a brief litigation process that is provided for, that's meant to be an alternative to litigation. And there are several services, like the one listed here, that provide these types of services. There has certainly been a judicial and legislative policy to encourage these types of alternate dispute resolution, mediation, and arbitration, because, again, there is a sense, a reality that litigation is very expensive, very risky, very time consuming, and it should be viewed as a last resort. Now we'll cover some recent laws relating to community associations. The first recent law several years ago now that should be discussed is the Nonprofit Corporations Law. Obviously, since we're all here today by their good graces. This is replacing another comprehensive law that replaces an existing RCW 2403, the statute governing nonprofits. And this is something, once again, that requires, I think, guidance, or at least you should consider guidance, is it establishes its own requirements for record keeping. Now, its requirements, I think, largely overlap what the requirements in the Kiowa statute and that we'll discuss in more detail here. But it's a separate set of requirements if you're a nonprofit corporation that you should at least be aware and supplement as required. Once again, meeting minutes, records of actions taken by unanimous consent by the owners, communications, for 6 years in this case, annual reports, accounting records. A lot of this is intuitive, but once again, these statutes are providing a list of categories. And so you will need to review those or be aware of those in order to make sure that you're, covering all of those. The standard of care for the nonprofit corporation law and for Kiowa, as we'll see, is just a reasonable person standard, ordinarily prudent person, and they are exercising the authority in a manner they reasonably to believe to be in the best interests of the community, of the association. And so that is a fairly broad standard. It's not a fiduciary standard. It's not as stringent as that, but it certainly is a standard that requires you to be informed, and it requires you to perform an adequate investigation and to be even-handed, consistent. The Nonprofit Corporation Act does require, though, if the association is not yet incorporated, to obtain a federal employer identification number, which is a step that many associations might not have taken yet. The most important recent law is, as I said, the Washington Uniform Common Interest Ownership Act, Kiowa, which is this 64 RCW 6490. This law is meant to replace in 2028 all of the other laws that apply to community associations. And I'm calling them common interest communities at this point, CICs. These are defined as real estate regimes where an owner of real estate, by virtue of their ownership of that property, is obligated to pay a share of expenses relating to other real estate, typically common elements. These are, once again, primary. If the governing documents, if they conflict with Kiowa and these provisions, then those governing documents are void and are not enforceable. So it's important to understand that what's in your governing documents may not be the correct legal standard. And that's something that I'll emphasize at the end as well, is that another confusing aspect of this is your governing documents might be misleading given subsequent state laws. So this is primary. It applies in full, as we discussed, with any common interest community created after July 1st, 2018, so the newer ones. For all the older ones, though, there are 5 sections, which I'll list here, which apply to them as well, all associations. The first one, it permits those associations, those CICs, as I should call them, to opt into Wakaiowa before the beginning of 2028. This is a 67% vote of the owners present. So not 67% of the whole association, but 67% approval of an amendment adopting Wakaiowa, opting into Wakaiowa, if there's a quorum of at least 30% of the owners participating in the vote. So a low, meant to be a low bar that allows, even in advance of 2028, existing condominiums and homeowners associations, allows them to adopt Wakaiowa early. The second provision that applies to everyone is that if there is restricted to, if the CIC is restricted to non-residential use, then that is not subject to Wakaiowa. So there, once again, is an exception. The third is that it changes the budget process. And this is a major area in which many associations are inadvertently doing it wrong. This portion of it states that CICs have the power to adopt budgets and impose assessments in accordance with Wakaiowa. And then fourth is the in accordance aspect. This portion of Wakaiowa, RCW 6490525, it contains a brief procedure regarding budget ratification that I mentioned before. And it's an opt-out standard. First, budgets have to be provided to the owners. Meetings have to be scheduled 40 to 60 days later. And unless owners holding at least 51% of the total voting power reject the budget, it's ratified whether or not a quorum is present at that meeting. So it's once again, low bar. It's meant to give the board a great deal of power, de facto power, in assessing the owners for the reasonable, necessary common expenses. And lastly, fifth, this portion of Wakaiowa, which applies to everyone, states that there have to be reserve studies obtained based on, as I said, visual inspections by reserve professionals and various other requirements. That applies to everyone at this point, based on Wakaiowa. Some associations have decided that it is in their interest to adopt Wakaiowa early for various reasons. One of them, though, is that many associations, primarily condo associations, are required to obtain a 90% vote of their owners plus affected owners to impose any kind of a leasing restriction in their community, which is something that many condo associations want to do. And so in this case, it lowers that bar to a 67% vote, but also it gives, in a separate section, Wakaiowa, it gives the board a limited, once again, authority to adopt leasing restrictions on its own if it's necessary to facilitate or to obtain access to loans to the financing market. So Wakaiowa does grant the board more power in this instance to both obtain assessments and to impose rental caps. Another benefit is an expanded lien, and it has certain restrictions on it in terms of the collection of that, but there is an expanded lien right for all associations for delinquent assessments. The standards regarding rulemaking and notice are established. One difference is that now, based on Wakaiowa, now this is something that does not apply to everyone yet, but it will in 2028. The standard is that the board must provide a comment period, notice and a comment period for any sort of new rule or amended rule. Before, the board could just adopt a rule, added an open meeting, and could notify the owners of it. Now, after 2028, or for the newer associations after 2018, the board must provide the owners with notice that it's considering a rule and give them an opportunity to comment on it, an adequate opportunity before adopting the rule. So that is a difference in terms of, once again, a procedural difference. There are also a number of specific restrictions on the types of rules and the types of use restrictions that can be made by either the board or the association. We'll discuss several of those, in this presentation. Standards regarding delinquent assessment collection are established. Those are restrictions. Those will apply to everyone in 2028. Some of them already apply to everyone now. But these are, the association has to jump through certain hoops, procedural hoops, once again, before it can collect delinquent assessments from owners, meant as a consumer protection policy. However, there are a lot of limitations as part of Wakaiwa as well, which some of these apply, to everyone. Some of these apply to only some. But there has been a marked change in the policy favoring flags, solar panels, adult family homes. There have been a number of changes that restrict the association, the CIC's ability to prohibit them at the very least. And in some cases, they're specifically permitted, but the association is given the ability to regulate them. So there are restrictions that the association's board has to be aware in terms of whether it is adopting rules or amending rules in the correct manner and according to the correct procedures. In terms of the sale of properties, there has to be public offering statements in the first instance or resale certificates when the unit is sold. There are recent electronic notice and meeting laws separate from Wakaiwa, although Wakaiwa includes them as well. They apply to all CICs, including those pre-Wakaiwa communities, once again. They amend the existing statutes, and they provide a lengthy framework with regard to different types of notice, whether it's notice in writing or notice electronically. It provides a lot of detail as far as notice, how meetings are conducted, voting procedures. What it's meant to do primarily, though, is it's meant to authorize the association to meet electronically through either conference telephone or Zoom or Teams or any sort of electronic medium. And it's also meant to allow for, in certain cases, it's meant to allow the association to notify owners by email if they've consented. In terms of these types of laws, once again, if this law is primary, and so if your governing documents are inconsistent with it, in many cases those governing documents will be inaccurate. And because in some cases, this electronic notice and meeting law states whatever's in the governing documents, regardless of the governing documents, here are the ways in which you can notify owners, or here are the ways owners can vote, or here are the types of meeting laws, standards that apply. The CICs can notify owners of meetings by electronic means, by email or other electronic means, but they have to have their prior written consent first. And so I'm aware that in some instances, an owner has in effect given their consent by accepting a notice. And I think that that is probably enough. But the legal standard is that you as a board should insist to get some type of signed document from an owner before you start notifying them by email, because that is the requirement that's placed. The associations obviously can meet remotely at this point. That's become the standard for a lot of associations. That's something that is provided for in state law, both in the Nonprofit Corporations Act and in Wakaiwa. In terms of voting, there can be voting by proxy, there can be voting by U.S. mail, and electronic transmission as well in connection with a meeting. So there are it's meant to provide as much voting methods, as many voting methods, and as many methods of meeting as possible in general. There are minimum meeting notices. 14 days. In some cases, some associations had 10-day standards, and so that's a relatively minor increase of 14 days, and maximum is decreased to 50. And so in some cases, it was 60 there. So the minimum is increased by a little bit, and the maximum is decreased by a little bit. The records law, which we will just be able to really scratch the surface of the recent records laws that have come out over the last couple of years. Some of this is intuitive. Once again, your budget, accounting records, including receipts, invoices, and other correspondence within the last 7 years. Once again, meeting minutes, actions they're taken by the association by a vote of its owners, committee reports, those sorts of matters, they should be intuitive, and those are I'm trying to hit the high points of this here. But there are many other in the statute. There are many other requirements, and this is for everyone. Once again, not just not just Wakaiowa communities, but for everyone. There are a number of records that you're required to keep, and really any type of assessment or any type of rules enforcement should be backed up by all of the documents. Is a good rule of thumb. Continuing with this, obviously your governing documents, your annual financial statements, tax returns if applicable, and these are the kinds of contracts, things of that nature. It's a long list, but these should be maintained securely, and that can be done electronically, but they should be maintained securely and consistently over long periods of time, typically 7 years. And finally, on this slide, and I think this is perhaps not intuitive, any kind of materials that have been required, that have been considered by a board or a committee to arrive at a decision, to justify its decision, should also be kept. And then at a minimum, you should be referring to it in the meeting minutes, but it's better to if you relied on, an opinion of an attorney or another professional or some other information, statute, or portion of the governing documents, then that should be something included as well. The notices provided to the owners is another intuitive. But also, and this is not so much, is the ballots in the last bullet here, the ballots, proxies, absentee ballots, and other records relating to voting for at least a year. That is obviously a much less requirement, just to give the owners who might want to challenge the vote, once again, the inadequate opportunity to do so based on the contemporaneous records. So that's a smaller standard, but you should keep everything, including the ballots and all the notices and the spreadsheets. Keep everything for a year relating to any kind of a vote. Association records have to be made available to the owners. There's a very broad right, excluding certain confidential matters, certainly attorney-client, matters, some enforcement matters, but generally speaking, association records have to be made available by examination for examination, copying by the owners. However, that does not mean that the owners have the right to require you to identify and provide specific records as a board or a property manager even. It is an option for you to do so in order to facilitate a records review. However, if you do so, then you can also have the option to say, we will provide you with our records, our access to our records, but you have the responsibility to identify the records and copy them yourself. That is an option. And once again, for an owner that is perceived to be abusing the system, that can be your ultimate response, is simply, we have an obligation to make the records available, but we don't have an obligation to provide you with those 60 records that you requested individually. And as far as as I said, the confidentiality, you have to consider whether there are financial aspects or legal aspects to the information that might violate privacy laws or otherwise be confidential. And that's something that is often specified in the governing documents. Foreclosure laws, briefly, these apply to everyone. All the statutes were amended, and it is meant to provide some limits on the association's right to collect assessments, particularly through foreclosure. Uh, it cannot, the CICs cannot commence foreclosures until there's at least 3 months of assessments or $2,000 owing. Again, a fairly low bar. However, it's interesting in the case of the 2000 is homeowners associations with relatively small annual assessments, that can be something that requires them to wait 4, 5, even 6 years before they can take meaningful enforcement action, i.e., foreclosure, to collect that debt. So that is a significant restriction on homeowners associations. And there have to be certain notices, certain disclaimers that are provided by the association or its property manager or attorney as part of this process. And certain waiting periods are required as well. In terms of some of the restrictions on the association's powers, if you will, electric vehicles are one aspect of this. There's been a major push by the state to encourage electric vehicles. And so there are state laws now that will not permit community associations to, as the state law says, effectively prohibit or unreasonably restrict owners' ability to install electric vehicle charging stations within their unit's boundaries or their parking space boundaries. So, if an owner requests the ability to do so within their property, not a situation in which the owner insists that the association has to provide them, but if the owner wants to build one on their property, then that's something that the association is required to permit within reason. The association can, in advance, impose reasonable restrictions on charging stations. It's more questionable when the association and the board have a response approach where it only formulates rules in relation to or in response to a violation. It should be done without responding to a violation in a normal meeting setting where you provide, after a comment period, the owners with an approved rule that states here are the restrictions on electric vehicles, and that's the statute, what it requires. However, this only requires the associations to permit, in most cases, electric vehicle charging stations. It does not require the owners, to be given free electricity by the association. They still are responsible to pay for any electricity use that's from the common expense. Childcare laws, once again, this is another policy that has been adopted by the state legislature to encourage, daycares. And so any sort of family home child license center or daycare center, once again, cannot prohibit or unreasonably restrict or limit them. There can be some restrictions placed on their effect on the community in terms of parking and noise and so forth, but they can't be prohibited outright because there is a policy to encourage them. The associations, as the middle portion of this slide indicates, those are some of the restrictions that can be put on them, and including indemnification. You can say any problem that happens on this property is not, even in a common area, is not the association's responsibility. Leasing, same matter, is that there are certain protections, in this case on tenants, that have become a strong state policy. But the association is permitted to require the use of a tenant screening service But strangely, the associations are not able to require that those reports or information be furnished to them. They are only required they're only authorized to require that the owners obtain them. So that is perceived by some to be a strange standard because the association has no way of verifying that the report was actually obtained. And so, or evaluating it at all. But it's, kind of a half and half situation there. In conclusion, I want to emphasize is that these are the major areas, resources, reserves, records, and rules that the board should be informed about its responsibilities through both the state law and through its governing documents, what the standards are, what the categories are, say, of records that need to be maintained, and follow that. And if there's any case of doubt or dispute, that is what professionals, are for, whether it's attorneys, property managers, accountants, bookkeepers. There are many resources that are available to a board that are better, I would submit, than trying to locate the answer, on your own through the internet. Though I certainly can tell is that there are a lot through my own experience that it is often wrong, or it's often misleading because it will give you a general sense of at least, at least state law that may or may not be in your jurisdiction, but it's not something that is good about nuance. And that is where I think individualized attention is required. Before we get into the questions, I do want to encourage that if you found this presentation helpful, or you have suggestions to improve it or additional questions, please complete the survey that's located here. We have a QR code for you, and that will help us to understand how to improve the next one. I believe that we're planning on another presentation in the fall, and that presentation will include a discussion of some of the very recent laws that have been approved or in this last session over the last several weeks, and will not take effect for several more months. So there are regular presentations that address the changing landscape, not just of state law, obviously, but of case law as well from a legal perspective. There are always new standards, new rules to be aware. And having someone that is in the area and keeps up with the latest developments is important, I would submit. So with that, I will open it up. We will open it up to questions about these matters. But I would encourage everyone to remember once again is that I have to keep this general. And it is something that I can't respond to specific situations. I can only comment more generally on a topic area, or a responsibility as covered here. So,
Great.
Melissa, as far as the chat goes, I mean,
Yeah.
are there any that have been chatted in?
Yes, absolutely. I'm going to go ahead and unmute Daz and allow you to to ask your question. And just real quick, the engagement survey link is also available in the chat if you would like to do
Yes.
that. Daz, go ahead and ask your question.
Hi, folks. Can you hear me?
Yes, we can.
Thanks, Kevin. This was an interesting presentation. I'm on the board of a small 25-home community in Duval.
Mm.
You ended your presentation talking about the need for professional services. I'm sure you guys are aware many people live in HOAs in the state, and many of those would prefer to think that the HOA doesn't exist. They want to kind of live their lives and not worry about it. We're concerned on the board that Wakioa adds a lot of bureaucracy to HOA communities.
It does.
We've spoken with law firms because, of course, every time you ask a legal question, you have to talk to a law firm and pay them money. And we're looking at like $10,000 in fees alone, not board time or any other factors, just to get our existing governing documents compliant with WCIOA. This is obviously challenging to take to our homeowners because A, they pretend they don't live in HOAs, B, they don't understand what WCIOA is. I wonder whether the state, and you may be challenged to answer this, whether the state has any understanding of the consequences of WCIOA on the majority of the state's residents.
Well, there are comments that are available to read, of the legislature and its thought process, if you will, with regard to the adoption of the statute. I know, speaking generally, that it was a partnership between industry groups and professionals that again specialize in this area and certain interested lawmakers, legislators. But you're correct, is that it was meant to be a comprehensive statute. It was meant to be a one size fits all. And so I agree with you, is that it is not as good of a fit for the smaller associations that are typically informal and have limited budgets. Those are associations that, yes, will struggle to absorb a 10,000 hit for legal fees for restating, replacing their governing documents. It's a lot for an association that has no dedicated legal budget, and many do not. That's something that I will say at this time, is that at this point, given the shifting landscape and the complexities and the bureaucracy, at least upcoming, it does seem as if it's almost an imperative, once again, for an association to get some legal guidance about what standards apply and all of that. So it's difficult, but and that a legal budget should be established for that. But I will say that I represent a lot of smaller associations. Most of my clients are in the small to mid-size range. Uh, and I recognize those difficulties. And so I try to provide differing layers of service, some of them that are less expensive. Uh, some of them are, the less expensive options have drawbacks, of course, limitations, but something is better than nothing. And I try to be pragmatic and say to associations is that this, starting in 2028, it will apply to common interest communities, condo associations, homeowners associations. It will apply to all of them, no matter what their governing documents say. Just, I think that you start there. It will apply regardless. So whether you amend, restate your governing documents or not, given that, it would be, in my mind, a bare minimum requirement would be is that you be aware of that as a board over time and comport yourself accordingly. Comply with the state law as you interpret it, you're aware of it. Again, hopefully with at least some legal guidance. That would be a bare minimum, is to act accordingly. But if you did want to record something less than a full restatement, which is expensive. I mean, 10,000 is not an unreasonable estimate for all the work that goes into the product and then the adjustment, the revision of the product. So I don't have any problem with that. I will say that the legislature, I think, knew that it would be expensive for many associations, and so it wanted to give them several years to budget for it. To say, well, we're going to give you 25, 26, and 27 potentially to budget for this to lighten the load a little bit. So they're trying. I'll give them credit. They're trying to not only be thorough, but also to give the associations a chance to raise the money for the optimal solution, which is yes, to replace your documents, which are obsolete in many cases and misleading, with a new document that reflects current law. Obviously, that's the best solution. I would just tell you is that there are lesser solutions. One of them is just a two-page document, really, which states we recognize, the association, recognizes is that Wakaiowa 60 RCW 6490 applies to us and refers all future boards to that law. I mean, that's better than the previous auction, which is not amending at all and just acting in accordance. The next best option, short of a restatement, would be a document which I have helped draft for a number of smaller associations, which is again a compromise between minimal and the full Monty, if you will. So it is a document that is meant to amend certain key portions of your existing governing documents that are likely to be used again and again. They're common portions of it, like budgets, like records, like reserve studies. These are continuing obligations. It's likely to come up in the future and repeatedly. So for those types of matters, I think it is worth considering to buy half a loaf and simply say, give us the 5 or 6 most important topic areas that we're likely to encounter and give us the new language for that. Uh, is it ideal? Is it comprehensive or complete? No, but it's
Kevin,
better than nothing.
I'm so sorry to interrupt. We do have several other folks who
Yes.
have some questions, and I just want
So,
to be mindful of time. I did
so
drop
that was the
Kevin.
end of that part.
Okay, perfect. I did drop Kevin's contact information in the chat. Daz, if you wanted to follow up on that question. Thank you so much.
But that was
Thank you,
actually, yes, the
Kevin. Thank you,
conclusion we have.
Melissa. Thank
Oh,
you.
absolutely. Next up, I have Chris Partridge. I'm going to go ahead and unmute your mic so that you can ask your question. And then I believe G-Sun and Susan will be up after that. Thank you, everyone.
Thanks, Kevin. Can you hear me?
Yes.
I had 2 questions that I hope are both pretty quick. One was, you mentioned under Wakaiowa that contracts have to be maintained for 7 years. I was just looking for some specificity. Does that include just like contractor estimates and invoices and other repair type work that the association has done? Are those considered contracts, or is it
Yes,
bigger
those are
things than that?
related to the contract. I mean,
Okay.
certainly, even if they are not contracts, they are related to one.
Okay, thanks. And then the second question was, you mentioned the requirement for a reserve study. Does
Yeah.
Wakaiowa still provide for a small association to waive that requirement if they vote?
Well, no, I mean, it requires something different, which is, it's something I can't, list off to you offhand, but it does maintain the ability to, for an association, that it would be an unreasonable financial burden to claim an exception. But
Okay.
I know what you're describing is that there was previously, and there will be for a couple more years, as I said, the ability to vote every year and waive it. But they waive certain, like audits, for example, and reserve studies. But in this case, no. I mean, once Wakaiowa kicks in, it's a broad requirement.
Thank you.
All right. Thank you so much, Chris. G-Sun, I believe saw um, your hand raised, but then I think it went away. I wanted to give you an opportunity to ask your question. I've gone ahead and unmuted your mic if you want to. No? Okay. So we will move on to Anne. If you're still with us and would like to ask your question, go ahead. Suzanne? Okay. Looks like we've lost those two. Does anybody else have any questions? Feel free. Oh, question from Colin. Can you share any references or resources on how to find reserve study professionals, Kevin?
Well, that is an area actually where a simple search, online, it will be effective. Washington State Reserve Study Professional, a search for that will give you several options. Yeah, I think that those are. I don't have any other resources beyond something general like that. There are many, and there are certainly, if you contact any property manager or attorney, they probably have references for you, but I don't offhand, no. Other than there are many reserve professionals with an online presence, certainly. And for reserve professionals as well, I mean, I think, there is a range, once again, in terms of how expensive that is. For a homeowners association or a plat community that has few common areas, it should be something that's pretty straightforward and therefore much cheaper. But for a condominium, it's going to be something that's more involved.
Great. Thank you for that question, Colin. Any other questions? Feel free to drop them in the chat or in the Q&A or raise your hand so that I can unmute your mic. And as you're contemplating, again, we do have the post-engagement survey. The link is available in the chat as well as the QR code on your screen. We are always looking to improve, and so your input is very important. Looks like the Lookout HOA had posted a question here. We are a 9-unit HOA. Do we need a reserve study?
I don't recall if it's 10 or not. There is a 10 or less, and I believe that that is an HOA with, I think it's 10 or less. The current standard is that I think that you have an exclusion, I believe. That's something that if you did want, to contact me directly, I could find the specific statute and so send you a link to it. That is one of and again, giving someone specific advice is more difficult because there are conflicting standards. There are literally 3 or 4 different standards that apply, and it really depends on when the association was created about what standard applies to you now. But I do believe that in the Wakaiowa part of it, which applies now, I believe that you're still required to get one. That it is a standard of 10% of your budget. So it's my understanding, just offhand, is that the Wakaiowa standard it superseded that 10-unit standard from the previous HOA Act. That's my recollection. But these are the types of questions that are really important, to get to the bottom of them and seek, legal guidance if you need it. If you look at the state laws that have been referenced in this presentation, they're all available. Once again, simple search online, RCW 6490 will give you the section, and then the reserve study portion of it is, I believe it's 6490 545. And I believe that was cited here. So take a look at that. I believe that has an exception in it for, again, 10% of the annual budget. So that might be, I mean, if you priced it out and it was at least 10% of your annual budget, then we would have an exception, I believe.
Right. I just did hear from Suzanne. We're having some technical difficulties. Suzanne, if you can hear me, please email me your question and I will make sure to highlight it here in the group. In the meantime, John from Up HOA in Seattle, I'm going to go ahead and allow your mic so that you can ask your question that you posted in the chat. If you want to unmute yourself. All right, I will go ahead and just read. Have CICs dealt with anonymous voting for electing boards when each unit has a fractional weight? That is, it's not one unit, one vote.
Right. In terms of just the procedure of it. Because yes, I mean, in terms of the fractional vote aspect of it, there's usually not a standard. There's not a standard in state law that it pertains to that. It's usually a majority of the votes represented, and yes, you do. The voting is almost always by that fractional percentage, and that's a condominium. That's something in condominiums. They're assigned for both common element responsibility and then also voting percentage, a fraction of a vote. And so that is, you would want to have a majority of the owners present at the meeting to elect a director, for a director to win an election. I believe that that's what the question was. Yeah. But yeah, quorum has to be met once again. If you're talking about meeting procedure, there will be a quorum that is stated typically in the bylaws, if not in the CCRs or declaration. That quorum has to be identified. If there is no quorum, are certain statutory minimums that you then would have to default to, the 34%, the 25% for condos. So, but once you have the quorum, then it's just a majority vote of that quorum as to who wins the election. And that majority vote is determined by the fractional. Yeah. So a majority of whatever total fractional, interest is represented.
Okay.
But in HOAs, it's always one. It's almost always one owner, one vote.
It looks like John has added the law states anonymous, non-identified voting.
What? The law. There is a provision, and this is an area where, once again, I can, if they want to follow up once I've had an opportunity to confirm, then because this is outside of, I think what we specifically covered in the presentation. I, there is a provision, as I recall, in the meetings portion of Wakiowa, 6490, that states that that it has to be an anonymous vote. Is that, and that I believe that that's the case, yes, for new communities. That is something that I do not believe was incorporated into the other three statutes applying to older community associations. I'd have to check.
All right, and
I
our
believe that I
last,
believe it was, yeah. But, in terms of the
okay.
meeting because some of the meeting portions of that statute did apply to everyone. Yeah.
Okay, great. And John says, thanks. Good to know. Good to learn. And I did receive the question from Suzanne, and that is, we are having trouble convincing our community to approve an assessment to fund the legal fees required to amend our governing documents originated in 1998. We cannot even get half of the required votes to approve. Any suggestions?
Well, the main aspect of this to consider is that the board has the power of the purse. And so the board can make a decision that it is going to propose that assessment in a budget. And it's going to provide for that at least a portion of that funding to be included in the next budget that it approves. And at that point, if the owners ratify the budget, then that money that money is free for you to use for that purpose. So really, it's an assessment ratification, budget ratification question. The board has the primary authority to decide whether to pursue these types of expenses, these types of amendments to the governing documents. What it doesn't have the authority to do is spend money or to collect money and then spend it without giving the owners a chance to rise up, so to speak, and reject it. And that's what the budget ratification is all about. If the board provides for the assessments and the budget's ratified, then it can spend those assessments collected on that for that purpose. Yeah. But that speaks again to there were issues that other homeowners associations faced in the past that led to litigation where they could not obtain a quorum. There was such owner apathy that they could not even obtain enough people to vote and to attend a meeting in order, even by proxy, in order to do anything, to increase assessments or to amend their documents, anything. And so, I mean, this budget ratification law was in part a response to that, where it recognized is that the board is given a lot of authority, a lot of power in the state legislature, the state laws, and in the governing documents to make decisions on behalf of the association. And one of them, the state law says is the budget subject to ratification. And as I said, it is certainly true that the ratification provision is almost always going to result in ratification. It is a very low bar to meet. And in almost 100% of the cases, whatever the board approves is going to be ratified. Few exceptions. So you should be able to collect the money. That's what I'm saying. But how much you collect, I mean, and over what period of time? That's the real question. I mean, how do you opt for a full replacement, or do you opt for something less than that? And do you collect all the money and perform the work this year, next year, 27? There are options you have.
Great. Well, thank you so much, everyone. If there are no further questions, I want for providing us this slew of amazing information with regard to community associations and interpreting Washington state law. As he mentioned, we are looking to provide this presentation later in the fall. So do tell your colleagues at other HOAs to be on the lookout. We thank everyone and hope that you can provide some feedback in the post-engagement survey. And we hope that everyone has a lovely Mother's Day weekend. Thank you so much.
Indeed, indeed. Thank you for being here.